Over 12,000 people were deported from Canada last year, and that number is expected to skyrocket in November 2025. What's even more shocking, many of them had no idea they were at risk until it was too late. You might think that can never happen to me, but new rules are now targeting people for things as simple as posting the wrong photo on social media or working a few extra hours on a student visa. Sounds unbelievable, right? But it's real, and it's happening faster than ever. In this video, we're diving into 10 new deportation rules that could impact international students, skilled workers, permanent residents, and even long-term immigrants with families here. Rule number 10 might just be the most shocking of all. It can reopen old cases and send people packing with just 30 days notice. So stick around. This is one video you can't afford to skip.
Number 1. Stricter work permit violations. If you're in Canada on a temporary work permit or as an international student, pay close attention because one wrong move could now mean automatic deportation. Under the new rules starting November 2025, the Canadian government is cracking down harder than ever on violations related to work permits. In the past, you might have received a warning or a chance to correct your mistake. But now, repeat offenders can be removed from the country without a second chance. Here's what this means. If your permit says you can work 20 hours a week and you're caught working even 25, you're technically breaking immigration law. And if it's not the first time, that's all it takes. The system is now integrated with employer records, SIN tracking, and even tax filings, so it's easier than ever for authorities to flag violations. This rule doesn't just affect students. Temporary foreign workers, TFWs, in industries like agriculture, hospitality, or trucking are also under the microscope. Overworking, working for an unauthorized employer, or taking up side gigs like Uber or delivery apps, all of these could now lead to deportation proceedings. It sounds harsh, but the government argues it's necessary to protect the integrity of the immigration system. Still, for many people just trying to make ends meet, it feels like a trap. So, what can you do to stay safe? Know exactly what your permit allows and stick to it religiously. If you're unsure, contact an immigration consultant or lawyer. Don't rely on advice from friends or random online forums. Don't risk your future over a few extra hours of work. If you're finding this helpful so far, give this video a thumbs up, hit subscribe, and share it with someone who might be at risk without knowing it. The next rule is even more surprising, and it's catching people completely off guard.
Number 2. Crackdown on fraudulent applications. One of the most alarming changes in Canada's new deportation policy is the zero-tolerance stance on fraudulent applications, even if the mistake seems small or unintentional. Starting November 2025, any misrepresentation on immigration documents, no matter how minor, can lead to immediate removal from the country, and in some cases, a 5-year ban from reapplying. What exactly counts as fraud? It's broader than you might think. Incorrect employment dates, undisclosed travel history, failing to mention a past visa rejection, all of these now fall under misrepresentation. Even if the error was made by a consultant or agent on your behalf, you will still be held responsible. This change is especially dangerous for people applying for permanent residency, study permits, or spousal sponsorships. In recent months, several applicants were deported after immigration officials discovered that a supporting document was either incomplete or outdated. One applicant was removed after failing to update their marital status, something they thought wasn't relevant anymore. The Canadian Border Services Agency, CBSA, has increased its use of AI-powered verification tools, which cross-check your submitted details against international databases, past visa records, tax filings, and even social media activity. That means your application is being scrutinized more deeply than ever before. This shift has created a climate of fear and confusion. Some newcomers are now double and triple checking their application forms out of panic. While being cautious is good, the real takeaway here is this: accuracy is everything. Even a small oversight can have life-changing consequences.
If you've already submitted an application, it's wise to review your documents to ensure they reflect the truth in full detail. If you're in the process of applying, don't rush. One small mistake today could become the reason you're forced to leave tomorrow.
Number 3. Tighter ties to criminal offenses. One of the most controversial changes in Canada's new deportation rules is the expanded connection between criminal charges and immigration status. Beginning in November 2025, even minor criminal offenses, ones that previously would not trigger removal, can now result in deportation without appeal. Under previous laws, there was a distinction between serious crimes and minor infractions, especially for permanent residents. A shoplifting charge, for example, might have led to a warning or a fine. But under the new system, even first-time, nonviolent offenses like petty theft, possession of a small amount of drugs, or driving under the influence, DUI, could now be enough to initiate removal proceedings. This is especially concerning for long-term PRs who've built their lives in Canada. Imagine living here for over a decade, raising your children, paying taxes, only to be deported over one bad decision. In many cases, these individuals may not even realize the severity of what they're facing until it's too late. What's changed is the government's threshold for serious criminality. It has been lowered, and the emphasis is now on whether the offense shows a risk to public safety regardless of the actual sentence given. This means that if a police report paints a troubling picture, even without a jail term, immigration authorities can act swiftly. In 2024 alone, over 4,000 permanent residents were deported due to nonviolent criminal charges. That number is expected to rise sharply in 2025. Adding to the challenge is the faster communication between police departments and immigration authorities, thanks to new digital sharing systems. In many cases, a criminal charge automatically flags your immigration file, starting a process that's hard to stop. The message is clear. Even one legal misstep can now carry devastating consequences for your immigration status.
Number 4. Social media surveillance. In a digital world where nearly everyone shares their life online, few realize that their social media activity could now be used against them in immigration cases. Starting November 2025, Canadian immigration authorities are implementing enhanced surveillance protocols that allow them to monitor public social media content to identify inconsistencies in applications or violations of immigration terms. What does this mean in practice? Imagine a student posting photos of themselves working long hours at a restaurant, far beyond the 20-hour weekly limit, or a visitor sharing pictures from what looks like a job site despite holding a tourist visa. In both cases, those seemingly innocent posts could trigger deportation proceedings. This isn't just about photos. Even comments, location tags, or status updates can raise red flags. For example, someone claiming to live in one city on their application, but constantly posting from another may be flagged for further investigation. Likewise, posts that contradict financial declarations, such as photos suggesting luxury purchases while claiming low income, can lead to suspicion of fraud or misrepresentation. What makes this rule especially tricky is that it doesn't require proof beyond doubt. Authorities only need a reasonable belief that your online presence contradicts your official status or story. That alone can be enough to launch a case. Immigration enforcement is now using AI tools to scan social platforms for keywords, locations, and activity patterns that don't align with declared visa conditions. This silent surveillance has caught many off guard, often when it's too late to explain or correct the impression. The key takeaway? Your online life is no longer private. If you're in Canada on any temporary or conditional status, think carefully before you post. Your next update could do more damage than you think.
Number 5. No-show at immigration appointments. Missing an immigration appointment might not have seemed like a big deal before. Maybe you forgot, got stuck at work, or didn't think it was urgent. But under the new rules rolling out in November 2025, failing to show up for mandatory immigration interviews, hearings, or check-ins can now be seen as a deliberate act of noncompliance and could lead directly to deportation proceedings. This change affects a wide range of people,
from refugee claimants and asylum seekers to those renewing permanent residency cards or attending status hearings. Under the updated policy, missing just one appointment without proper explanation is enough to raise a red flag. Miss two, you could be considered uncooperative and be added to a removal watch list. What's especially concerning is that delays or rescheduling, which were previously allowed for valid reasons, are now much harder to obtain. The process for requesting a new date has become more complex, and missing deadlines in that process can close your case altogether. This policy shift is part of a broader move towards streamlining immigration enforcement, making it easier for authorities to categorize individuals as non-compliant. And once you're labeled that way, it's extremely difficult to reverse the decision or appeal the outcome. Many people underestimate how strictly these timelines are enforced. Something as simple as changing your address without updating the immigration office could result in missed letters and appointment notifications, and missing those letters counts the same as ignoring them. In today's tightened immigration climate, every missed appointment is treated as a potential red flag. If you're involved in any kind of immigration process, it's now more important than ever to stay organized, keep records, and never underestimate the importance of showing up.
Number 6. Removal of compassionate grounds appeals. One of the most heartbreaking changes in Canada's new deportation rules is the removal or severe limitation of appeals based on compassionate grounds. Until now, individuals facing deportation could request a review based on factors like having Canadian-born children, serious health issues, or being deeply integrated into the community. These human elements were often considered when deciding whether someone could remain in the country, even if they technically violated immigration rules. But starting November 2025, these compassionate appeals will carry far less weight and, in many cases, may not be accepted at all. The new policy is shifting toward a law-first approach, which prioritizes the strict application of immigration regulations over personal hardship or emotional circumstances. This shift is already causing concern among advocacy groups and legal experts. Take the case of a woman who has lived in Canada for 15 years, has 2 children in school, volunteers in her community, but failed to renew her PR card on time due to a medical emergency. Under the old rules, she might have had a chance to stay based on her strong community ties. Under the new rules, that emotional and social connection might not be enough to stop her removal. The government argues that this change is about ensuring consistency in how laws are enforced, but critics say it dehumanizes the immigration process, stripping it of the flexibility needed to consider real-life complexities. This rule is especially dangerous for vulnerable populations, elderly parents, refugees, caregivers, who may not have strong legal grounds to stay but have deep emotional and family roots in Canada. With compassion no longer a safety net, immigrants are now expected to rely strictly on legal compliance, no matter how genuine or difficult their circumstances may be.
Number 7. Faster processing for deportations. Another major change coming in November 2025 is the dramatic acceleration of deportation processing times. What used to take months, sometimes even years, can now happen in a matter of weeks, thanks to a new system designed to streamline removals and reduce legal backlogs. Previously, individuals facing deportation often had the opportunity to build a legal defense, gather documents, and appeal decisions over extended periods. In many cases, people were able to stay in Canada for years while their cases were under review. But under the new framework, the government has cut these timelines significantly, with some deportation orders now being processed and enforced within 30 to 60 days. The goal, according to immigration officials, is to eliminate abuse of the appeals process and prevent individuals with no legal status from remaining in the country indefinitely. However, for many people, especially those unfamiliar with legal procedures or those without proper representation, this speed leaves little room to respond. One of the most concerning aspects is the use of expedited removal orders for failed asylum seekers, visa overstayers, and individuals flagged for misrepresentation. Once these orders are issued, there's very little time to react or mount a defense. Miss a deadline?
your deportation could proceed automatically. Additionally, the new process reduces access to in-person hearings, replacing many of them with digital reviews or paper-based decisions, which can be much harder to contest or clarify. While this may sound like an administrative upgrade, for those affected, it feels more like being fast-tracked out of the country, sometimes without fully understanding why. The pressure is now on immigrants to act quickly, keep their documents ready, and stay alert to any notices, because delays, even unintentional ones, could cost everything.
Number 8. Visa overstayers now prioritized. In the past, visa overstayers in Canada were often treated as low-priority cases, especially if they had no criminal record and were living quietly. But under the new deportation rules taking effect in November 2025, that's changing dramatically. Now, anyone who overstays their visa, even by just 30 days, can be flagged for immediate removal, and these cases are being pushed to the top of the enforcement list. This change affects a wide range of people: tourists, international students, temporary workers, and even individuals waiting on immigration decisions who let their status lapse unintentionally. The new policy no longer views overstaying as a minor issue. It is now classified as a direct violation of immigration law, and authorities are under instruction to process and remove overstayers swiftly. One of the biggest risks is that many overstayers don't even realize they're in violation. A delayed extension approval, an expired permit, or confusion about the exact expiration date can all lead to someone falling out of status without meaning to. But under this policy, ignorance is not an excuse. Once the system identifies a lapsed visa, the person may receive a removal order with little warning. The CBSA has also begun using automated flagging tools to identify expired visa holders through entry and exit data and employment records. Once flagged, individuals may be monitored more closely, making it even harder to stay under the radar. Previously, many overstayers had time to seek legal help or apply for restoration, but now that window is shrinking, and in some cases, closing completely. The message is clear: if your visa is about to expire, take action before the deadline, because once you cross that line, the new system may not give you a second chance.
Number 9. Sponsorship breakdown consequences. One of the lesser-known but increasingly impactful changes in Canada's deportation policy is the tightened consequences of a sponsorship breakdown. As of November 2025, individuals who are in Canada under a family sponsorship, such as spouses, parents, or dependent relatives, could face deportation if the sponsor withdraws their support, even after years of living in the country. Previously, there was more flexibility in handling sponsorship breakdowns, especially in cases involving domestic disputes, financial hardship, or family separation. But now, the immigration system is treating a broken sponsorship as a violation of residency conditions, particularly if the sponsored person is unable to prove financial independence or hasn't yet obtained permanent residency. This rule disproportionately affects spouses in vulnerable situations, such as newcomers experiencing abuse or abandonment, who may now be faced with the devastating choice of staying silent or facing deportation. Likewise, elderly parents who rely on their children's financial support may be ordered to leave if the sponsor claims they can no longer provide for them. Immigration officials are now verifying ongoing sponsor support more frequently, especially during PR applications and renewals. If a sponsor revokes support, claims financial strain, or is found to have provided false information, the person they sponsored could receive a removal notice within weeks. There is also greater scrutiny on marriage-based sponsorships, with periodic reviews to ensure the relationship is still valid. If the marriage ends within a certain period, especially before PR is granted, the sponsored partner may lose their status entirely. The core issue here is the increased dependency the system places on sponsors, and if that relationship fails, the consequences fall hardest on the sponsored individual. Now, without a backup plan or legal support, many could find themselves suddenly at risk of losing everything.
Number 10. Retroactive rule enforcement. Perhaps the most alarming and controversial change in Canada's new deportation policy is the introduction of retroactive rule enforcement. This means that new immigration rules can now be applied to past cases, even if those cases were previously resolved or considered closed under the old pause. In other words, you could be deported today for something that wasn't grounds for removal last year. This shift is creating widespread uncertainty and fear, especially among people who thought their situations were already settled. For example, someone who received permanent residency 5 years ago, despite a minor misrepresentation, such as an unreported job or a small error in their application, could now have that case reopened and face deportation under the new stricter rules. Even individuals who were granted appeals or temporary stays based on compassionate or humanitarian grounds are no longer guaranteed protection. Immigration officials now have the authority to review and reassess old cases in light of the updated regulations, and if they find a violation by today's standards, they can issue a removal order immediately. This rule change affects thousands of immigrants, especially those with pending applications, appeals, or old infractions in their immigration history. Legal experts are warning that retroactive enforcement creates a dangerous legal gray area where no one is fully safe, even those who followed the rules as they existed at the time. The rationale behind this move is to close loopholes and ensure that immigration decisions reflect current national priorities. But for many, it feels like a betrayal, a sudden rewriting of the rules after they've already played the game. Now, more than ever, immigrants are being urged to revisit their old documents, applications, and decisions, because what once seemed like a harmless oversight could now be a reason to lose their place in Canada. The new deportation rules taking effect in November 2025 are more than just policy changes. They represent a major shift in how Canada handles immigration enforcement. From stricter work permit regulations and faster processing times to the alarming rise of retroactive enforcement, these updates are sending a clear message. Compliance is no longer optional, it's essential. What makes these changes especially concerning is how broad and unforgiving they are. A missed appointment, an old mistake on a form, or even a post on social media could now be enough to put someone's entire future in Canada at risk. Many of the safety nets like compassionate appeals or the assumption of innocent mistakes are disappearing. And for thousands of people, the consequences could be life-altering. It's no longer enough to simply be in the country legally. You now need to be hyper-aware, fully compliant, and constantly on top of your immigration status. Whether you're an international student, a temporary worker, a permanent resident, or someone waiting for a decision, these rules apply to you. Now is the time to get organized, review your documents, stay updated on the law, and seek trusted legal advice if there's even the slightest uncertainty in your status. Because as we've seen, the system is changing fast, and it's not giving second chances. While these changes are meant to strengthen the immigration process, they're also creating a climate of fear and confusion. Staying informed is your best protection. Don't assume you're safe just because everything seems fine today. Under these new rules, everything can change overnight. Your future in Canada may depend on what you do right now to protect it.